Once again, this is Dr. M.R.K. Prasad, Dean Faculty of Law, Goa University, and also Principal of V.M. Salgaonkar College of Law, Goa. Today we would be discussing the access to justice issues relating to the children. You all know that the children are very special. They are more vulnerable compared to the others. Therefore, we would be discussing today on Protection of Children from Sexual Offences Act, which popularly called as POCSO Act, which came into force in 2012. The basic objective of today's lecture, or what we are going to discuss on today's lecture, if I put in different manner, we would look into what sexual offences covered under this act. We look in when Indian Penal Code is already dealing with the offences against human body, which also includes sexual offences, why we need a special act dealing with sexual offences against the children, and we will also look at what are the new authorities created under the act, what are their key roles, how do they deal with child victims in case of sexual abuse. We will also appreciate that this act prescribes several child-friendly procedures to be followed by the authorities as well as the court, and what necessitated this kind of procedure to be adopted. And we also look into the establishment of a special court exclusively to deal with the sexual offences under the POCSO Act. So to start with, the Protection of Children from Sexual Offences Act received the assent of the President on 19th June 2012. It came into force on 14th November 2012. It applies to whole India except the Jammu Kashmir. And we all know that the Jammu Kashmir has a special status, therefore this law would not apply to them. Then, in addition to the act, the POCSO rules were framed by the government in 2012. They were notified on 14th November, from where the rules also came into force. What is the purpose of bringing this act? Because as we just a few minutes ago I said that the penal code is already having punishments for the sexual offences, but why we need such a special act in case of children? The study on child abuse India 2007, it is a research undertaken by the Ministry of Women and Child Development, and also a data that was collected from the National Crime Record Bureau, which we call NCRB, shows an increase in the cases of child sexual abuses. We all know that, first of all, the sexual offences do not report to the police because of various reasons. Well, one of the prime reason is, particularly when the sexual offences are against the women, it is considered as a taboo by the society. Therefore, many women, because of fear of backlash from the society, they don't even report it. When it comes to the children, it is still worse, because at times the children doesn't know that it is a sexual abuse because of their tenderness of the age, or sometimes they were afraid, and because of that there are very few cases that reports. And also there is a need to penalize the perpetrators of such crime, who usually known to the children in most of the cases. And the act also looked at how to protect the children from this kind of sexual abuses, and how do we safeguard them at every stage of the judicial process. Because if you recollect, the trial proceedings before the court, particularly in sexual offences, is more humiliating, and at times the victim feels that the trial is more cruelsome than the rape itself. And because of that, many people are discouraged to come to the court for the justice, and keeping that in view, the Act actually looked at the best interest of the child as a basic principle to follow under the POCSO Act. So, the Act was enacted by the Parliament because the Indian Penal Code did not specifically provide sexual offences against children. It does not mean that there are no provisions. There are provisions on sexual offences, but they are general in terms and mostly are heavily tilting towards the abuse against the adults. And one notable what I could call is omission from the Indian Penal Code is that the sexual offences against the boys is not covered. So, the rape law or outraging the modesty of the woman and other provisions on sexual offences under the Indian Penal Code are only against the women. So, it is not looking at the male counterparts. So, therefore, there is a special need for a special legislation which could cover all these aspects. And in addition to that, the most important push factor for bringing this act is the United Nations Convention on Rights of the Child, which was adopted in 1989. And further, if you all recollect, Article 15 Clause 3 of the Indian Constitution also enables the state to make special provisions for the children. So, therefore, the Act was passed keeping all these needs in mind. So, let us quickly glance what are the salient features of this Act, then we will go into specifics. To start with, the Act defines child as a person who is below the age of 18 years. So, therefore, if you look at different legislations dealing with child has a different definition regarding to the age. Some acts talks about child below the 14 years, some of them talks about 16 years, some of them are 18 years. But as far as sexual offences are committed under POCSO, any child below 18 years is covered. Therefore, whenever we are referring the word child means the child below the age of 18 years. The offence of sexual assault, sexual harassment, pornography are defined for the first time in law, because they were not defined under the Indian Penal Code in relating to the sexual offences. The Act also provides stringent punishment for these offences. There is also a provision for fine under the Act. And in addition to providing or defining what is sexual offences, the Act also deals with aggravated form of offences. So, an offence is considered as an aggravated when it is committed by a person in position of a trust or an authority of the child. That means an offence committed by another person may be an offence, but if it is the same thing committed by a person in authority would amounts to aggravated offence. And further, the Act also says attempt to commit an offence is made punishable with up to half the punishment prescribed by the Act for commission of an offence. So, if commission of an offence gives 10 years imprisonment, an attempt to commit such same offence would give you 5 years imprisonment. Further, the Act also talks about punishment for abatement. It says that the punishment for the abatement is same as the offence committed. So, it is very stringent in that sense. Act also provides speedy trial for the cases, and there is a special juvenile police unit or the local police to provide relief and rehabilitation of the child in case of sexual abuse. And it also says within 24 hours of recording of the complaint, the special juvenile police unit or the local police shall report the same to a child welfare committee, which is a mandatory requirement. the duty is cast upon the state and the central government to spread the awareness about the Act. So, these are the salient features of the Act.